10.2 Agent Leverage Tool KIT. The purpose of this guide and attached worksheet is to assist you, the agent, in determining if the recommendation of borrowing to invest meets the leveraging guidelines. The guide will summarize your obligation to your clients with regards to introducing leverage, explaining the risks of leveraging, using the worksheet and submitting the application for compliance approval, assist you in the process and expectations of WFG when you are recommending borrowing for investing. It is not a training program to educate you on the concepts of leveraged investments. Please note that as an agent who recommends borrowing to invest, you must have already completed the WFG leveraging course and have done your own self-training to fully understand these recommendations. In addition, you are expected to be familiar with the WFG's leveraging parameters. See Appendix A for WFG Agent Leverage Worksheet. 10.3 Introducing leverage to clients. Borrowing money for investment purposes is not suitable for everyone. Prior to making this recommendation to a client, you must first determine if the client has the proper investment knowledge, risk tolerance, and financial objectives to meeting the parameters of the WFG leveraging guidelines. It is imperative that you provide the client with a balanced presentation of the leveraging strategy and other investment options available. You must be able to demonstrate through your client notes and financial plans that the client was given the appropriate information to make an educated decision to borrow money for investing. A balanced presentation would include explanations regarding different account types, RSP, TFSA, open, as well as concepts such as dollar cost averaging and compounding interest. 10.4 Explaining the risks of leveraging. A leveraging disclosure document must be provided to your clients at the time your client is opening a leveraged account. This disclosure document explains in plain language the risks associated with borrowing to invest. However, it is your duty to review this disclosure fully with your clients. It should be documented in your client notes that the risks have been reviewed and note any specific questions your clients may have had during this discussion. 10.5 Exit Strategy. In addition to reviewing the risks in the disclosure document, you must also review an exit strategy with your clients. Generally, the exit strategy includes a review with the client as to what would be involved with surrendering the account and repaying back the loan under certain circumstances. Worst-case scenarios should be reviewed. For example, should there be a loss of income, can the clients continue to meet the payment requirements with other resources? If not, are they prepared to repay the loan even if there is a shortfall? 10.6 Leverage Review Worksheet Instructions. This worksheet is intended for the use of the agent and branch managers for the pre-approval of the leverage recommendations. It will also assist you in assessing the suitability of existing leverage in accounts and if an additional loan falls within the parameters. The worksheet is an essential part of the pre-approval process. If fully and properly completed, the worksheet will help accelerate the approval process and minimize additional inquiries from operations and compliance. You are able to populate the shaded areas of the worksheet. The rest of the spreadsheet is locked. The worksheet completes the calculations to confirm if the parameters of the leveraging guidelines are being met. You must add your notes into the worksheet on page 2. These sections ask you to detail what information you considered in order to determine the risk tolerance and investment knowledge. If the client holds current investment loans, or invested money from a HELOC, you must enter the current balance of these loans in Section 4. Section 6 will then calculate how the current loan meets the parameters and how the total leveraged amount held by the client meets the parameters. Please note that the entire leveraged amounts held by the client, S, must fall within the recommended parameters. Should a loan fall outside of the parameters, you, as the representative, must advise in the comments section as to why the loan is suitable and an exception should be considered. 10.7 Submitting the leveraged account for approval. All documentations must be submitted to your branch manager for review and approval. Prior to sending it to WFG Dealer Connect, WFG DC, for processing. Once the branch manager has reviewed and approved the leverage recommendation, all documentation should be sent to WFG DC for processing. WFG DC will provide all documentation to WFG Head Office Compliance for approval. The leverage recommendation file should include the new account application form/KYC form applicable at the time of the leveraging recommendation, the loan application, S, the leverage disclosure document, documents supporting or pertaining to the client's income, T-slips, notice of assessment, etc. Financial plan, S. Documents supporting or pertaining to the client's net worth including account statements, property tax assessments, appraisals, etc. Client risk assessments or investor profile questionnaires. Any marketing of the leveraged strategy or illustrations/projections of investment returns or the future value of the account. Notes of client meetings or discussions, and any other documents relevant to the review of the leverage strategy. 11.0 Continuing Education and WFG. 11.1 Additional Training. WFG Insurance Offering. Leveraging Course. All newly licensed associates who intend to use leveraging strategies for their clients as of March 1, 2007 are required to take the WFG Leveraging Course through Oliver's or the IFIC Leveraging Course. Associates licensed on or after March 1, 2007 must successfully complete the course before they use leveraging strategies. The associates that were licensed within the 1-year period from March 1, 2006 to February 28, 2007 must successfully complete the course within 1 year, while WFG Insurance strongly encourages all licensed associates to take the leveraging course. Associates that were licensed before March 1, 2006 are exempt from taking this course unless the compliance department requires them to take it. Associates that do not intend to advise on leveraging will not be required to take the course. Regional branch managers are required to monitor and keep records of all associates and whether they have passed or failed the course. This information should be readily available for review. 11.2 Continuing Education. Each life insurance agent is responsible for meeting the CE requirements of their respectful provincial regulators. 12.0 Anti-money laundering. 12.1 Introduction. Money laundering is generally defined as any act or attempted act to disguise the source of money or assets derived from criminal activity. Essentially, money laundering is the process transforming money, produced through criminal activity, into clean money, whose criminal origin is difficult to trace. We are responsible to ensure that specific measures to detect and deter money laundering and terrorist financing are implemented throughout the organization. 12.2 The Compliance Regime. A compliance regime has been implemented at WFG. The compliance manager has been identified as the compliance officer responsible for overseeing the anti-money laundering procedures and practices of the company. The compliance manager reports directly to the chief compliance officer. A review of the compliance regime and AML/ATF policies, procedures, and training will be conducted every 2 years or sooner if required by regulatory changes. Policies. Procedures and training will be approved by senior management or external auditors, if deemed necessary. 12.33 Stages of money laundering. Placement. Criminal proceeds are deposited into legitimate organizations. Layering. Complex layer of financial transactions to make audit trail difficult to follow. Back to the crime. Integration. Seemingly legitimate proceeds are placed back into the economy. 12.4 Process for reportable transactions. Each transaction or attempted transaction provides a potential risk for money laundering or the possession of terrorist property. WFG is required to make reports relating to the following transactions. Transactions identified as suspicious of money laundering and/or terrorist financing. The existence of terrorist assets. Large cash transactions. An attempted transaction that is deemed suspicious. 12.5 Process for identifying suspicious transaction. Generally, items identified that may raise suspicion or warrant further investigation include, but are not limited to, frequent deposits and/or withdrawals from the same account or same client. Frequent deposits and/or withdrawals from accounts being serviced by the same agent. Frequent deposits and/or withdrawals from accounts that seem to held by related people. Surrenders that suffer large redemption fees. Surrenders of large amounts shortly after deposits, specific to one client's accounts, or a few clients belonging to the same agent. Suspicious trends that reoccur over a period of a few months either with the same account or agent. Staff have been made aware of a large wire transfer into the trust account. Staff have been made aware of a large money order purchase. The following are examples of situations that may be deemed suspicious. The existence of one or more of these behaviors from a client may not confirm money laundering activities. However, these are suspicious indicators that raise concern regarding the integrity of the business being placed. Client shows no concern for redemption charges. Accounts are surrendered shortly after opening, with no reasonable explanation. Client wishes to purchase a number of investments with money orders, travelers' checks, cashier's checks, bank drafts or other bank instruments, where the transaction is inconsistent with the normal investment practice of the client or their financial ability. Transfers of funds or securities between accounts not known to be related to the client. All principals of client are located outside of Canada. Proposed transactions are to be funded by international wire payments. Staff is made aware that the client is associated with or working on behalf of individuals believed or suspected to be related to terrorist financing activities. Normal attempts to verify the background of a new or prospective client are difficult. Accounts that have been inactive suddenly experience large investments that are inconsistent with the normal investment practice of the client or their financial ability. Any dealing with a third party when the identity of the beneficiary or counter party is undisclosed. Client attempts to purchase investments with instruments in the name of a third party. A specific distributor's office or agent requests the same or similar transactions on several accounts belonging to clients that seem to be unrelated. 12.6 Process for reporting suspicious transactions. In accordance with FinTrack procedures and the Proceeds of Crime, Money Laundering and Terrorist Finance Act, PMELTFA, any employee or entity that makes a report in good faith is protected from criminal and civil proceedings. FinTrack applies a high standard of privacy protection to the personal information under its control. To promote privacy, PMELTFA contains a number of provisions relating to the protection of information and privacy. It specifies the particular circumstances under which designated information may be disclosed by FinTrack. In any other case, the center is prohibited, as are its employees, from disclosing any report received or any information. Note, it is important that a client or agent does not become aware that you have deemed a transaction suspicious and are considering reporting to FinTrack. Should the initial inquiries satisfy a trade suitability concern but still not eliminate your suspicions of the transactions, no further inquiry is required. However, the transaction should be reported as per AML procedures. Step 1. Identification of a suspicious or attempted suspicious transaction. The following steps must be followed if you deem a transaction to be suspicious. Bring the suspected situation to the attention of your manager. Complete a copy of the Suspicious Transactions Alert Form Appendix B. Document the details of the case, include time and date and the factors that you have decided may be suspicious. Create a file, which must include copies of all applicable documents and the Suspicious Transactions Alert Form Appendix B. Provide the file to your manager for review. Step 2. Manager Review. The manager will review the file to ensure all applicable documents are included and that the Suspicious Transactions Alert Form Appendix B has been completed with all information available. Step 3. Compliance Reporting to FinTrack. The manager will provide the file to compliance for reporting and filing. If deemed necessary, compliance report the transaction to FinTrack as per the online reporting system. All files will be retained in the compliance department. 12.7 Process for identifying and monitoring politically exposed persons, PEPs, and heads of international organizations, HIOS. Effective June 23, 2008, securities dealers must include a risk assessment to identify high risk situations for money laundering and terrorist financing, where account holders might be PEP. At the time of account opening, all sales agents will be required to ask their clients specific questions to determine if the client is a politically exposed person. An additional question has been added to the KYC/NCAF application to record this information. A foreign PEP is a person who holds or has held one of the following offices or positions in or on behalf of a foreign state: head of state or government, member of the Executive Council of Government or member of a legislature, deputy minister, or equivalent, ambassador or an ambassador's attaché or counselor, military general, or higher rank, president of a state-owned company or bank, head of a government agency, judge, or leader or president of a political party in a legislature. A domestic PEP is a person who holds or has held within the last 5 years a specific office or position in or on behalf of the Canadian federal government, a Canadian provincial government, or a Canadian municipal government. Governor General, Lieutenant Governor, or Head of Government. Member of the Senate or House of Commons or member of a legislature. Deputy Minister or equivalent rank. Ambassador, or attaché, or counselor of an ambassador. Military officer with the rank of general or above. President of a corporation that is wholly owned directly by Her Majesty in right of Canada or a province. Head of a government agency. Judge of an appellate court in a province, the Federal Court of Appeal or the Supreme Court of Canada. Leader or president of a political party represented in a legislature, or mayor. The head of an international organization, HIO, is a person who is either the head of an international organization established by the governments of states, or the head of an institution established by an international organization. A person would also be considered PEP or HIO if any of the above apply to a family member such as mother or father, child, spouse or common law partner, spouses or common law partners, mother or father and brother, sister, half-brother or half-sister, that is, any other child of the individual's mother or father. Once a client is identified as a PEP or an HIO, the PEP Verification Supplement Appendix C must be completed and provided to head office compliance along with all account opening documentation. The PEP status is recorded on the system for tracking. In addition, the account must be approved by senior management prior to any transactions taking place. PEP files are maintained in the Compliance Department. 12.8 Process for identifying potential high-risk clients. It is the expectation of FinTrack that a risk assessment is completed with each client in relation to the client's business activities. Knowing clients is not limited to the identification requirements. The expectation is that there is an understanding of the activities, transaction patterns, and how he/she operates. A client assessment should be completed where there is an ongoing relationship with the account holders. Client Business Relationship Checklist, Appendix D, is recommended to be completed by the agent after the initial client meeting and maintained in the branch client file. The checklist should be updated as the client relationship develops and more information is known about the client. Should there be a concern with a specific client, this must be brought the attention of the compliance officer. Note that the questionnaire should not be completed with the client, but rather after the meeting. A client should not be notified if they are deemed as a potential risk. If a client is identified as a potential risk, the report must be provided to the Compliance Department. The Compliance Department will review and assess the risk. The requirement for further account monitoring will be considered. 12.9 Processes for record keeping. Client identification must be verified on the new client application form/KYC. This document is maintained in the client file as per the Compliance Procedure Manual. Information is also recorded in the back office system as required for account opening purposes. Identification kept on file must be kept up to date and reviewed at least every 2 years. Mutual fund dealers will be prohibited from opening an account if we are unable to establish the identity of the client. 12.10 Business or company name accounts. When opening an account for a corporation, in addition to the new client account opening application, confirmation of the officers who are duly authorized to act on behalf of the company must be obtained and maintained in the client file. This can be any one of the following: the certificate of incumbency, the articles of incorporation, or the bylaws of the corporation. You also have to determine the names of the corporation's directors. To do this, you may need to see the list submitted at the time of their application for incorporation. The record you use to confirm a corporation's existence can be paper or an electronic version. An electronic version of a record has to be from a public source. For example, you can get information about a corporation's name and address and the names of its directors from Industry Canada's Strategies Federal Corporations database on the Corporations Canada page of the Directories of Canadian Companies site. If the account is for an entity that is not a corporation, in addition to the new client account opening application, the name, address, and principal business or occupation of the entity must be recorded. To confirm the existence of an entity other than a corporation, refer to a partnership agreement, articles of association, or any other similar
record that confirms the entity's existence. Copies of all documents or internet searches must be maintained with the client file with additional copies submitted with the account opening documents for processing. The beneficial owners must be identified. These are any individuals that own or control 25% or more of the shares of the corporation or entity. Therefore, director, beneficial owners. of corporations and non-corporate entities form, Appendix E, must be completed, if the client documentation provided does not address the above required information. 12.11 Guidance Manual. Agent obligations under the PCMLTFA are fully described in the Guidance Manual provided by the CLHIA. 13.0 Privacy and PIPEDA. 13.1 Introduction. As of January 1, 2004, all businesses and individuals in Canada, including managing general agencies, including WFGIA insurance, and licensed insurance agents, are subject to legislation that regulates the collection, protection, use and disclosure of personal information. In provinces that had enacted legislation by January 1, 2004, that was substantially similar to the Federal Personal Information Protection and Electronic Documents Act, PIPEDA. These activities will be governed by such provincial legislation. Quebec, British Columbia, and Alberta have their own provincial privacy legislation that is substantially similar to PIPEDA. These provincial laws will apply in these provinces. The collection, protection, use, and disclosure of personal information in all other provinces and territories, as well as the collection, use and disclosure of personal information in the course of interprovincial and international commercial activities, will be governed by PIPEDA. WFGIA Insurance is responsible for the protection of personal information and the fair handling of it at all times, throughout the organization and in dealings with third parties. Care in collecting, using and disclosing personal information is essential to continued consumer confidence and goodwill. The Act recognizes the individual's right to privacy, the need for an organization to collect, use or disclose personal information for legitimate purposes, and establishes rules for handling personal information. 13.2 What information is considered personal? Personal information is factual or subjective information about an identifiable individual. Examples are, but not limited to, all health information or health history, religious beliefs, home address, blood type, DNA code, fingerprints, sexual orientation, education, home telephone number, date of birth, marital status, banking information, financial information, income, name, age, weight, height, purchases and spending habits, opinions, political or party, affiliations, evaluations, comments, social status, disciplinary actions, race and ethnic origin, credit records, loan records. Personal information does not include the name, title or business address and telephone number of an employee or information that you would normally find on a business card. The 10 Privacy Principles. There are 10 principles that are the basis for PIPEDA. These principles have been incorporated into WFGIA Canada's privacy policy. We must follow these principles for the protection of personal information. It is important that you understand these principles and WFGIA Canada's responsibilities. The 10 principles are accountability, identifying purposes, consent, limiting collection, limiting use, disclosure and retention, accuracy, safeguards, openness, individual access, challenging compliance. 1. Accountability. All employees, agents are responsible for compliance with WFGIA Canada's privacy policy and the 10 privacy principles. The Chief Compliance Officer and the Compliance Department are responsible for overseeing compliance with the privacy policies. 2. Identifying purposes. The purposes for collecting personal information must be disclosed either at, or before, the time of collection. A client's personal information will be used only as required for the product or service that they are purchasing, i.e., life insurance. A client's personal information may be used for any of the following reasons: confirm identity, determine eligibility, suitability or need for insurance and financial products, determine and verify creditworthiness for the financial and insurance products and services requested, administration and servicing, meet regulatory and contractual requirements relating to the services and products provided. If clients have provided written consent, WFGIA Insurance may use a client's personal information to provide the client with details regarding WFGIA insurance or products and services offered by us. A client may withdraw consent for this purpose on the application, or by contacting the compliance department. 3. Consent. For collection, the knowledge and consent of the individual are required for the collection, use or disclosure of personal information, except when inappropriate. Consent is only meaningful if the individuals understand how their information will be used.
We will also obtain the consent from the client prior to using personal information for a new purpose. Client consent for collection and disclosure can be provided either verbally or in writing. Expressed, for example, providing information on an application form, or implied, for example, not withdrawing consent when given the opportunity. Expressed consent should be used whenever possible and in all cases when the personal information is considered sensitive. This protects both the individual and WFGIA insurance and the agent. When obtaining consent, remember to record how the consent is received, by phone, in person, by mail or email, as a note or copy to the file. Never obtain consent by deceptive means. Explain to the individual the implications of withdrawing consent. For use or disclosure, situations may arise when you will be allowed to release a client's personal information without their consent. The two examples of situations that you may encounter are requests from regulators or reporting a suspicious transaction in accordance with our anti-money laundering policy. Examples of when not to release personal information: if the identity of the requester cannot be confirmed, a family member calls on behalf of the client but you do not have consent from the client to release the information, a representative who is not the servicing representative is requesting client information, a lawyer who has not provided evidence that he has been retained by the client calls and requests client information. A caller claims to be the policyholder's father and holds a prestigious status within his community, but you do not have consent from the client to release information. If you encounter a situation where it is unclear if information can be released, discuss the situation with your manager or a member of the compliance team prior to releasing any information. 4. Limiting collection. The type and amount of personal information collected must be limited to what is necessary for the identified purposes. All information will be collected by fair and lawful means. We may not collect personal information indiscriminately, and we must not deceive or mislead individuals about the reasons for collecting the personal information. 5. Limiting use, disclosure, and retention. Use, unless the individual consents or as required by the law, we may not use or disclose personal information for purposes other than the purpose for which it was collected. Disclosure: WFGIA Canada only discloses personal information to third parties with written consent from the client for the purpose of assisting us in evaluation of risk, investigations, servicing, administration, and claims. All of our service providers, with whom we have a contractual relationship, are required to protect personal information in accordance with our privacy policy. Examples of disclosing to third parties are service providers such as Fundex, product providers such as Transamerica, Equitable, and the Mutual Fund, companies, regulators. Retention: client information must be maintained for 7 years after the last transaction on an inactive account or the closing of an account. 6. Accuracy. It is your responsibility to keep personal information accurate, complete, and up to date. Only as necessary, taking into account its use and the interests of the individual. Clients have the right to request the correction of any inaccurate or incomplete information about them in our possession. 7. Safeguards. Personal information must be protected by security safeguards appropriate to the sensitivity of the information. Our responsibilities: protect personal information against loss or theft. Safeguard the information from unauthorized access, disclosure, copying, use, or modification. Protect personal information regardless of the format in which it is held. WFGIA Insurance takes measures to ensure clients' personal information is protected. The following examples should not be considered exhaustive. Physical measures like locking filing cabinets at the end of the day and restricting access to offices. Technical tools such as passwords, encryption, and firewalls. Organizational controls such as security passes, limiting access on a need-to-know basis. Staff training and employee agreements. The protection of personal information is a particularly important compliance issue when using technology. You must therefore take all the necessary precautions to avoid unauthorized access to your client's electronic data. You are responsible for carrying out all required precautions to protect client personally identifiable information, which is stored electronically. 8. Openness. WFGIA Canada's privacy policy is available for access on all of our websites. 9. Individual access. Upon request, a client will be informed of the existence, use, and disclosure of his or her personal information and will be given access to that information. A client must be able to challenge the accuracy and completeness of the information and have it amended as
appropriate. Upon written request, WFGIA Canada must provide copies of, or access to, the client's personal information. We are required to acknowledge this type of request within 5 days of receipt. The request must be fulfilled within 30 days. However, we cannot release any information that would reveal personal information of a third party. If you should receive a request from a client asking for a copy of their personal information, you must forward it to the compliance department immediately for handling. 10. Challenging compliance. An individual must be able to address concerns with regards to compliance with the 10 principles. As such, we have developed simple and easily accessible complaint procedures, which obligate us to investigate all complaints, notify the individual of the outcome of the investigation, take any relevant steps for correction. All complaints that are deemed to be privacy complaints should be forwarded to the Compliance Department for handling. 13.3 Failure to comply. Privacy protection is a necessary part of doing business in today's service economy. There can be significant risks and consequences, both commercial and legal, to our organization if we do not adequately address privacy. Failure to comply with the privacy legislation could result in investigation and audit by the Privacy Commissioner, a hearing in the federal courts, possible criminal charges, fines or imprisonment, damage to our reputation and business relationships, legal liability with industry sanctions, customer and employee distrust, lost business and consequential reduction in profits and market share. 13.4 Do not call rules for financial agents. On September 30, 2008, the CRTC published rules for telemarketer compliance with the Do Not Call (DNC). These DNC rules apply to agents, and it is important that you comply with the requirements. You cannot call potential clients without first checking the DNC list and confirming that their number is not on it, unless you have their express consent to do so. Getting written or email permission protects you in the event of a future complaint or dispute. Keep a record of any such consents provided by consumers in a file, as the onus is on the telemarketer to prove valid consent was given to you. The telemarketing rules do not apply to mail or email. Service calls to existing clients are not telemarketing calls and therefore not subject to the rules. A service call is a call that relates to insurance products or services that a client has purchased, applied for or made inquiries about, or is required by regulation and/or standards of professional conduct. An example of a service call would be if you prepare a financial needs analysis for a client and later call to discuss the products or services that this analysis identified. Certain types of calls are exempt from the DNC regulations. They are business-to-business calls, calls by registered charities, by political parties, to conduct public opinion, surveys, by newspapers to solicit subscriptions, calls made to consumers if you have done business with them within the past 18 months or within 18 months of a contract expiring, calls made by a consumer to you inquiring about your services within the past 6 months. Should you require more information, please contact the Compliance Department. 13.5 WFG Privacy Incident Policy. As per Section 2.18, in the event of a privacy incident of security safeguards, agents must contact WFG Compliance immediately. A privacy incident of security safeguards is defined in PIPTA as the loss of, unauthorized access to or unauthorized disclosure of personal information resulting from a privacy incident of an organization's security safeguards that are referred to in Clause 4.7 of Schedule 1 of PIPTA, or from a failure to establish those safeguards. WFG Compliance will undertake to report any privacy incident of security safeguards involving personal information under its control if it is reasonable in the circumstances to believe that the privacy incident of security safeguards creates a real risk of significant harm, ROSH, to an individual. Significant harm includes bodily harm, humiliation, damage to reputation or relationships, loss of employment, business, or professional opportunities, financial loss, identity theft, negative effects on the credit record and damage to or loss of property. Factors that are relevant to determining whether a privacy incident of security safeguards creates a real risk of significant harm include the sensitivity of the personal information involved in the privacy incident of security safeguards and the probability the personal information has been /is/ will be misused. 13.6 Reporting privacy incidents. Reporting of such a privacy incident will be undertaken to the Federal Privacy Commissioner, insurance provider, and affected individual, as soon as feasibly possible. After determining that the privacy incident has taken place, WFG undertakes to keep and maintain a record of every privacy incident of security.
Safeguards involving personal information under its control. Records of privacy incidents, as such, will be kept regardless of whether or not a real risk of significant harm has taken place. Records of all privacy incidents will contain the following information: date or estimated date of the privacy incident, general description of the circumstances of the privacy incident, with enough sufficient details provided for the OPC to assess whether WFG has correctly applied the real risk of significant harm standard and otherwise met its obligations to report and notify in respect of privacy incidents that pose a real risk of significant harm. In cases where WFG did not report the privacy incident to the Privacy Commissioner and notify individuals, a brief explanation of why WFG determined there was not a real risk of significant harm, nature of information involved in the privacy incident, and whether or not the privacy incident was reported to the Privacy Commissioner of Canada/individuals were notified. WFG will keep records of all such privacy incidents of security safeguards for a minimum of 2 years. WFG will also undertake to notify the affected individual, of any such privacy incident, using non-legalistic and easily understandable language. At a minimum, the notification will include a description of the circumstances of the privacy incident, the day on which, or period during which, the privacy incident occurred, or, if neither is known, the approximate period, a description of the personal information that is the subject of the privacy incident to the extent that the information is known, a description of the steps that the organization has taken to reduce the risk of harm that could result from the privacy incident, a description of the steps that affected individuals could take to reduce the risk of harm that could result from the privacy incident or to mitigate that harm, and contact information that the affected individual can use to obtain further information about the privacy incident. Once the immediate steps are taken to mitigate the risk associated with the privacy incident, WFG will thoroughly investigate the cause of the privacy incident and use the findings to develop and improve adequate long-term safeguards against further privacy incidents. 13.7 WFG Privacy Policy and Compliance. The clear and effective privacy policies at WFG Insurance Agency of Canada Inc. are applicable to all of its affiliates and their employees, officers, directors, distributors, agents, representatives, and service providers with whom WFG conducts business with, has entered contracts with, or has begun contract negotiations with. WFG believes that having a strong privacy and compliance policy builds trust among policy holders, account holders, and clients. In order to ensure compliance with all applicable privacy legislation, WFG has appointed a Chief Privacy Officer. All matters related to privacy issues can be forwarded in writing or by telephone to World Financial Group Insurance Agency of Canada Inc. 5000, Yonge Street Suite 800. Toronto, on M2 and 7 × 10 to the power of 9th. Telephone, 416-225-2121, option 3. 14.0 Other MGA rules. 14.1 Fee for planning. World Financial Group Insurance Agency of Canada Inc. does not permit agents to engage in the practice of fee for planning services. Agents are compensated through the sale of insurance products, any trails or commission generated from a sale, and any approved referrals that the agent engages in.